Okay, you ready for him?
Comment. It's the YouTube live thing is still on.
Okay, you ready for him?
Yes, ma'am.
Okay, that delay? And I said that 3 minutes ago. Okay, I will
Really?
admit.
It's delayed. Maybe you should use your phone. Okay, I'm switching to record now.
I guess Mr. Ephraim's not showing
Mr.
a
Ephraim,
mic yet.
Hello.
We got you, Mr. Salar.
you're fine.
Mr. Ephraim, are you there? He doesn't have a...
His microphone yet didn't show up. And just for your knowledge, Mrs. Slar, we have Athalia. She's a Cargill. She's a court reporter who's just sitting in today.
Okay.
Where'd he go? Okay, he's gone.
Maybe he'll sign back in because he's having difficulty. Let me get my glasses. I guess I'll pause the recording again since we're just sitting here. Kim will remind me to start it back up.
You know, I would ask you how the weather is, Judge, but I'm a little worried that Matt might accuse me of ex parte communications.
Weather's fine.
You know, I've seen a few attorneys have issues with their laptops on Zoom, and they usually just sign back in on their phones.
Right. Yeah, because I usually don't have too many problems with people logging in, but I know some of my colleagues have had problems.
Right. Yeah, for me, it's been totally fine.
Mm-hmm. Had you spoke with him earlier today?
No, I haven't had a chance to speak to him yet.
Okay. Okay, Miss Clifton, that looks like you. But still no.
There he is.
Hi guys, can you hear me?
We can hear you.
I don't know why my video's not working. I'm trying to figure out. I apologize. I signed off and signed back on trying to see if I could get the video to work here.
Have you done any today? Have you had any other?
Yeah, not conferences, but I did have a Zoom meeting today, and I've had several settlement conferences without any issue. And they keep saying Zoom is unable to detect a camera. Is there an options thing here? Yeah, I'm having a hard time.
Even Zoom doesn't want this motion to go.
Make sure your camera is powered on and connected to your computer. Let me just type in something really quick here. I apologize, Your Honor. I don't know why this is not, I see myself on the camera.
Oh, you do?
Yeah, it just says it's not. It's not detecting it on Zoom.
Would you be able to call in, or not call in, but use the Zoom app on your phone? Oh, some attorneys have done that when their laptops have malfunctioned.
I certainly could do that if that's something that you guys want me to do.
Go whatever's easier for you, as long as we get the ball rolling.
Do you
I
have
got some writing I gotta do today.
Do you need to see me to be able to hear the motion, have the settlement conference?
Not necessarily. We can
Um,
now let me just ask, do you have the Zoom app on your phone?
I have it on my personal phone, yes. Let me just go to video really quick. Always display, turn on my video when joining the meeting. All right, let's see if this helps. I went to options. It's having trouble connecting to the camera. I just went to options to see if that would help. This is frustrating.
Well, we can try to proceed, Mr. Evans.
Again, I apologize. I don't know why.
Ms. Cliff, you want to call the case?
This is case number 190000634 Ramon Israel versus Safeco Insurance Company of Illinois.
Council appearances.
Alex Salar for the plaintiff, Your Honor.
Good afternoon, Your Honor. Matthew Ephraim on behalf of defendant Safeco.
Okay, Mr. Ephraim, this is Safeco's motion, so you may proceed.
Yes. Your Honor, this is a case where the plaintiff claims that he was struck by an unidentified tortfeasor on April 9th, 2018, but the plaintiff has yet to prove that he was actually hit by another vehicle, which is required for our uninsured motorist policy to be activated. Liberty Mutual and Safeco policies contain a physical contact requirement in order to initiate the uninsured motorist benefits to reduce phantom vehicle cases like this one. More specifically, our policy states that if there is no physical contact with a hit and run auto, the facts of the accident must be proved. We will only accept competent evidence other than the testimony of a person making the claim under this or any similar coverage. There is no evidence here outside of the plaintiff's subjective statements. There must be competent evidence by someone other than the person making the claim. Uninsured motorist coverage is not required by statute, as you know, Your Honor. Therefore, this contract determines under what circumstances uninsured motorist benefits will be awarded. The plaintiff has had time to review this contract, ask questions, decide not to accept the contract. before he entered into the insurance contract. As for the facts of the alleged accident itself, oddly enough, the plaintiff was able to recall his injuries in detail in his deposition, able to recall critical details regarding the alleged incident with the phantom vehicle. The plaintiff could not even recall the name of the road he was traveling on or how many lanes were on the road. He did not know what the vehicle that allegedly hit him looked like. He did not know what kind of vehicle it was or what color the vehicle was. And if you look at Exhibit B, the plaintiff admitted that he didn't even see the vehicle that allegedly hit him. Then he said later in his deposition testimony that he did see the vehicle that hit him. Then he said he didn't see it again. So even if we were to take the plaintiff's testimony alone, which is not sufficient to prove that another vehicle hit his vehicle, his own testimony is inconsistent. There were 0 witnesses to verify that any vehicle other than the plaintiff's vehicle was involved in this alleged incident. Here, only the plaintiff states that he was hit by the phantom vehicle. Because the plaintiff is the only one involved in the accident or the only one with testimony regarding the accident, we would have thought that the plaintiff would have retained an expert.
I'm sorry. Recording.
Oh, God.
Hi, caramba.
This is a rough technological day.
Yeah, you know.
Yes, Your Honor, this is a failure. I just happened to notice that your record button is not on.
Okay.
Okay. Thank you for allowing me to sit in.
No problem. Okay, well, let's try it from the top.
And I'm still trying to get my camera going. I apologize, Your Honor.
Okay, that's okay. Counsel appearances for the, well, Ms. Clifton, can you recall the case?
Yes, ma'am. This is case number 1900634 NF, Ramon Israel versus Safeco Insurance Company of Illinois.
Okay, counsel appearances for the record.
Alex Salar for the plaintiff, Your Honor.
Good afternoon, Your Honor. Matthew from Safeco.
Okay, Mr. From again, this is Safeco's motion, so you may proceed.
Okay, Your Honor, this is a case where the plaintiff claims that he was struck by an unidentified tortfeasor on April 9, 2018. The problem here is that the plaintiff is yet to prove that he was actually hit by another motor vehicle, which is required for the uninsured motorist policy to be activated. Liberty Mutual and Safeco policies contain a physical contact requirement in order to initiate the uninsured motorist benefits to reduce phantom vehicle claims such as this one. More specifically, the policy states that if there is no physical contact with the hit and run auto, the facts of the accident must be proved. We will only accept the competent evidence other than the testimony of a person making the claim under this or any similar coverage. There is no evidence here outside of the plaintiff's subjective statements. There must be competent evidence by someone other than the person making the claim. As you know, uninsured motorist coverage is not required by statute. Therefore, this contract determines under what circumstances uninsured motorist benefits will be awarded. The plaintiff has had time to review the contract, ask questions, decide not to accept the contract before he entered into this contract. As far as the facts of this alleged accident itself, oddly enough, the plaintiff was able to recall his injuries in detail in his deposition testimony. He was unable to recall critical details regarding the alleged incident itself with the phantom vehicle. The plaintiff could not even recall the name of the road he was on. He couldn't recall how many lanes were in the road. He didn't know what the vehicle that allegedly hit him looked like, what kind of vehicle it was, what color the vehicle was. And if you look at Exhibit B, the plaintiff admitted that he didn't even see the vehicle that allegedly hit him. Then later he stated that he saw the vehicle coming towards him. Then he said he never saw the vehicle coming towards him in later testimony. Even if we were to take the plaintiff's testimony alone, which is not sufficient enough to prove that another vehicle hit his vehicle, his own testimony is inconsistent. There were 0 witnesses to verify that any vehicle other than the plaintiff's vehicle was involved in this alleged incident. Here, only the plaintiff states that he was hit by the phantom vehicle. Because the plaintiff is the only one involved in this accident, or the only one with testimony regarding this accident, We would have thought that the plaintiff would have retained an expert to attest to the accident's details or damage. The plaintiff did not retain any expert to evaluate the alleged damage to his vehicle. There was zero independent proof that the plaintiff's vehicle sustained any damage involving a collision with another vehicle. There's absolutely no evidence whatsoever that the alleged vehicle hit the plaintiff or that another vehicle was even involved in a motor vehicle accident. Furthermore, the plaintiff alleges a paint transfer. Yet the plaintiff has failed to hire an expert to prove that the alleged paint mark was there before or after the accident. It's just his subjective statement. For all we know, the paint mark could have been there for years before this motor vehicle accident. It would have taken an expert to prove that the paint mark was from another motor vehicle for this specific accident. The plaintiff did not take the initiative to meet his burden of proof. And it's not our job to prove that his vehicle hit another vehicle. It is the plaintiff's burden of proof. And Michigan courts have consistently upheld this physical contact requirement contained in insurance policies, such as ours here in Safeco's. This is designed to reduce fraudulent phantom vehicle claims, according to Hill versus Citizens Corporation of America, Michigan Appellate Court. Courts have consistently held that there must be actual physical contact between the hit and run vehicle and the insured's vehicle, and this is not Safeco's burden of proof. In Said versus Auto Club Insurance, 152 Michigan App 240, 1986, the court held that swerving to avoid a hit and run vehicle does not satisfy the physical contact requirement. Here, the plaintiff could not show. I'm sorry.
Mr. April, could you the case that you're finding?
Yep, it's Said SAID versus Auto Club Insurance Association, 152 Mich App 240. The year is 1986.
Okay, you may proceed.
And in that case, they said that swerving to avoid a hit and run vehicle does not satisfy the physical contact requirement. And in our case, the plaintiff cannot show physical contact between his vehicle and another vehicle. There's no testimony from the police officer, and the police report itself is inadmissible hearsay under the Michigan Rules of Evidence. And the plaintiff has failed to prove his burden that any sort of paint transfer or damage stems from another motor vehicle hitting his motor vehicle. The fact that Safeco chose to pay for physical repairs of the accident under a collision portion of the policy does not mean that the plaintiff has met his burden proving that his vehicle hit another vehicle under the uninsured motorist portion of the insurance policy. It's important to remember that, of course, under MCR 2.116C10, summary disposition is proper when there is no genuine issues as to material fact and the moving party is entitled to judgment as a matter of law. We also know that under MCR 2.116G4, it provides that a party may not rest upon mere allegations or denials of his or her pleadings, but it must, by affidavits or otherwise provided in this rule, set forth the specific facts showing that there's a genuine issue for trial. The reviewing court, as this honorable court here, considers affidavits, pleadings, depositions, admissions, and documentary evidence filed in the action or submitted by the parties in light most favorable to the non-moving party, of course. The plaintiff in this case has not submitted any additional admissible evidence to prove that his vehicle hit another vehicle. The plaintiff was also granted leave to file an additional brief in support of his position. He never filed that additional brief. He did not get it if there was one filed. So clearly here, the plaintiff failed to provide evidence to support that there was actual physical contact between the plaintiff's vehicle and any unidentified motor vehicle. The plaintiff has not hired any experts or deposed anyone, including the police officer. So, Your Honor, for these reasons, we respectfully ask the Honorable Court to grant our motion for summary decision under 2.116C8 and or C10 on the grounds that the plaintiff has failed to make a claim upon which relief can be granted, and that there are no genuine issues as to any material fact as to the plaintiff not being entitled to uninsured motorist vehicles. and that Safeco is actually entitled to judgment as a matter of law.
Mr. Sheila.
Your Honor, wow, where do I start? I could not disagree more on the facts. First of all, and briefly to address opposing counsel saying that we have a lack of evidence, we have a bunch of evidence. We have the pictures, we have the notes of Safeco's adjusters, we have the invoices from the repairmen that did the repairs to the vehicle that Safeco paid for itself. And, you know, we filed this lawsuit 8 months ago, and we would have had more evidence, but Safeco did not at all mention that they plan on bringing up this no contact defense until they filed this motion. They did not mention it in their affirmative defenses, and after losing their first MSD, they're going for a second bite at the apple, except this time they have an even worse conspiracy theory because they have no evidence supporting their allegations. In fact, they admitted in their filings that an accident did occur, namely in their December summary disposition motion. They said, on April 9th, 2018, plaintiff was traveling on East Poland Street when he was struck by an unidentified tortfeasor who was traveling west on Poland Street when the left side of the tortfeasor's truck struck plaintiff's vehicle. They call him a tortfeasor. They did not contest that there was contact throughout this entire lawsuit, and they have no evidence to support this no contact conspiracy theory. They rely only on the pictures of Ramon Israel's vehicle after it was repaired, and those are repairs that Safeco paid for. Indeed, before and after we filed this lawsuit, Safeco not once contested whether there was contact with another vehicle up until now. But now, in a last-ditch effort to maybe absolve themselves of responsibility, Safeco is trying to pass off these post-repair pictures as pre-repair pictures. That's nonsense. We have the actual pictures attached to our brief. This court properly denied Safeco's prior summary disposition motion, and this motion is no different. Safeco has no evidence to support, this 11th hour conspiracy theory that it just concocted last minute to get themselves off the hook. And here, there's at least a material fact issue worthy of a jury. And, I guess.
Excuse me, let me ask you one question, Mr.
Yeah.
Was there, I believe there is a police report?
There is a police report. I didn't mention it because that's an inadmissible hearsay, but we would have been able to depose the cop had we known they were going to bring this defense earlier.
Right. Now okay.
The supplemental brief is the last thing I wanted to mention. We got the order, but it kind of went under the radar and we didn't see it until after that 7-day window. So I figured since, more or less I made the same arguments in there, Matt would have notice of it and, we'd be able to put it on the record here. But even without the points in the supplemental brief, I think our attachments to our response, they speak for themselves and they speak volumes.
Right. And the court does have to take the evidence in the light most favorable to the non-moving party. And even though there's a disagreement with the facts, that then in and of itself is a sufficient enough basis for this matter to go forward. Also, we do have the pre-pictures, and there's an argument that Safeco made and can make relative to those. And the police officer, if there's a need to go to trial, of course, that police officer can be subpoenaed for trial. So, I do have to take the evidence in light most favorable to the non-moving party. And even though Safeco has advanced its position that the plaintiff had a thorough knowledge of his injuries, but no knowledge of the incident, I think that there is still information available because, like I said, of course, we can't admit the police report, but if necessary, and if Mr. Saylor does subpoena the police officer can testify at trial. And then there are the pictures, and Safeco has its position relative to the pictures, but the plaintiff has an opposing view. And that in it of itself creates a question of fact, whereby the court, taking the evidence in light most favorable to the non-moving party, does have to go forward and deny the motion based upon the fact that there are disputes here that can be submitted to the jury. So the court will deny the motion for summary disposition.
Thank you, Your Honor.
Okay,
Thank you, Your Honor.
Okay, so we have a settlement conference. Miss Cargill, I have one at 3 o'clock. If you like, we can replace you in the waiting room until that time.
Thank you, Your Honor. I would appreciate that.
Ms. Clifton, can you place her in the waiting room, please? Thank you. And I'm going to stop the recording and then we'll discontinue YouTube Live and we'll handle the settlement conference. Thank you. Give me 1 second.
Thank you.